Good afternoon, ladies and gentlemen. It's Tuesday, March the 5th, 2024. Welcome to the Civil Justice Subcommittee. Thank you for joining us today. Madam Clerk, take the roll.
Good afternoon. Representatives Bolso, Capley, Eldridge, Farmer, Grills, Lamberth, Parkinson, Todd, Chairman Russell.
Here.
Chairman, you have a quorum.
Thank you. Members, we have any personal orders today? Representative Grills, we're glad you could join us. All right. Seeing no personal orders, just as a reminder, members, if you vote in the opposition and wish to have your vote recorded as such, check in with TJ after the vote and have it recorded. So thank you for that. And just for a couple of house cleaning items, item number 3, House Bill 2282 without objection. Well, actually, correction on that. Let me look at this again. Number 5, House Bill 2117 by Representative Powers, rolled 1 week without objection. Item number 6, House Bill 2908 by Representative Kumar without objection, rolled to the March 19th calendar. Item number 8, House Bill 2695 by Chairman Doggett without objection, rolled to the March 19th calendar. Item number 9, House Bill 2595 by Representative Rudder, rolled 1 week without objection. Item number 11, House Bill 1904 by Representative Fritz without objection, rolled to March 19th. Item number 12, House Bill 1586 by Representative Pearson without objection, rolled to the March 19th calendar. Item number 13, House Bill 1588 by Representative Pearson without objection, rolled to the March 19th calendar. Item number 14, House Bill 1591 by Representative Pearson without objection, rolled to the March 19th calendar. Item number 15, House Bill 1594 by Representative Pearson, rolled to March 19th calendar. Brings us to item number 17, House Bill 2883 by Chairman Todd, rolled to the March 19th calendar. And members, without objection, got another page. Getting a little ahead of myself here. Item number 19, House Bill 1823 by Chairman Farmer, without objection, rolled to the March 19th calendar. Chairman Farmer, you're recognized.
Yeah, thank you, Mr. Chair. Just a preliminary matter. Have you been working out? Because you know, I had Chairman Curcio had a very strong, swift swing. Chairman Lamberth back when his time as chair, he had a very strong swing, and I sat in front of Chairman Zachary the other day and counted rules, and I was terrified. But you, sir, Mr. Chair, have taken the top spot.
Well, Chairman, I'm glad that you noticed that. I do get here pretty early in the morning and work out just for this committee, so thank you for that. Thank you. Representative Parkinson, you're recognized.
Thank you, Mr. Chair. And I want to thank Chairman Farmer for bringing that up, because as I was coming to sit down, I caught the pap in my right ear, and now I can't hear out of it. But thank you, Chairman Farmer. Thank you, Mr. Chair.
Thank you. All right, we're going to take item number 10 out of order, House Bill 2061 by Representative Hicks. We got a motion, and do we have a second? We got a second. Representative Hicks, you're recognized on House Bill 2061. I do show 2 amendments. Would you like to run one of them or both of them? Or?
Thank you, Mr. Chairman. I'll run one of them. The last one, you may read off the number.
Yes, sir, if you would.
014645.
That's what I show. Members, do we have a motion? We got a motion and a second. We're going to be voting on putting amendment number 014645 on the House Bill 2061. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Chairman Hicks, you're recognized on House Bill 2061 as amended.
Thank you, Mr. Chairman. And I can verify, Chairman Russell, I got to the gym at 4:20 this morning, and he was already there. So I can verify. This bill is agreed upon by the Tennessee Hospital Association, the Tennessee Sheriff's Association, private mental health facilities, and the Tennessee Department of Mental Health and Substance Abuse. When an involuntary committed person is released from a mental health institution, the releasing facility must notify law enforcement where the patient lives and where the mental health facility is located. They must notify both of those. It is done electronically. Out of state does not apply. If homeless, they must be notified law enforcement where the institution is located. Senator Wally was contacted by his sheriff regarding this issue at Western Mental Health Institute, which is housed in Bolivar. The notifications for all releases of involuntary commitments come to the local sheriff. However, many times these individuals are from other counties. Many of these patients are repeatedly involuntary committed and are a threat to themselves and others. So we just feel like that they should both be notified, especially where they're going back home. The law enforcement needs to know that they're coming back to where they live or, where they reside at. So with that, I'll be happy to answer any questions.
Thank you, sponsor. Very well detailed on the presentation. Representative Parkinson, you're recognized.
Thank you, Mr. Chair. I want to thank the sponsor for this bill, for what he's doing. But, we are in what I would consider an understated crisis when it comes to mental health. And, while this is great for, law enforcement and others to know, but a lot of times these individuals that are involuntarily committed or involuntarily committed and they're released within 2 or 3 days, they're still not fully stabilized in a lot of cases. And it's good for the individuals that you have in the bill to be notified, because sometimes these individuals still not fully stabilized will actually be wandering around in different cities and places, and their loved ones or others don't even know where they are. And so I appreciate you bringing this bill, man. This is a really good bill and very important bill. Thank you so much for bringing it.
Representative Hicks, you're recognized.
Thank you for those comments. I appreciate that. It's very important.
Thank you. Leader Lambert, you're recognized.
Thank you. I know we talked about this very briefly the other day, but there's another bill out there that notifies the transporting agency. Are you open to that idea? I mean, it's good to notify where the individual is headed to, but a lot of times there's a law enforcement agency that actually transported an individual to inpatient. And I know that's something that came up in special session, but I actually think we passed it in special session. Any thoughts on that or any objection to notifying both? I mean, both where the patient is headed to and the transported agency?
And members, you're welcome to go back and forth without being recognized.
Thank you, Mr. Chairman. I'm open to anything. I just need to, Senator Wally sort of brought me this bill, so I want to go through him to make sure of what his thoughts are on that. But yeah, I'm open to anything. Sure.
Thank you.
Thank you. Any further questions for Representative Hicks? Seeing none, we're voting to send House Bill 2061 to civil full. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Civil full.
Thank you,
Congratulations.
Chairman. Thank you, committee.
That brings us to the very start of our calendar. Item number 1, House Bill 2066 by Chairman Clemens. Do I have a motion? We got a motion. Do I have a second? Do I have a second? Then third and final call for second, Bill Phelps. Item number 2, House Bill 2449 by Representative Miller. And without objection, we'll roll House Bill 2449 to the Hill. Chairman Farmer, you're recognized.
Yeah, thank you, Mr. Chair, and I apologize. I didn't mean to interrupt
No,
you
you're fine.
as you're working. I ran into Representative Miller. I think he intends to roll this bill for a week. I think it needs some work, but I don't know if he hadn't contacted you then.
I believe he has. So let me reconsider my actions and roll him 1 week.
Very good.
Without objection, House Bill 2449 rolled 1 week. All right. Without objection, we'll roll item number 3 to the Hill. Okay, Representative Hawk, are you here? Yeah, he's not here. Well, without objection, item number 3, House Bill 2282 to the Hill. Item number 4, House Bill 2152 by Representative Kingsley. We've got a motion and a second. Representative Kingsley, you're recognized on House Bill 2152, and I do not show any amendments.
That's, yes, that's correct, Mr. Chairman. Thank you. Mr. Chairman, members, House Bill 2152 is local bill brought to Senator Yeager and I from the Scott County Commission. We do have a resolution for this request, and the abstract or the summary, and it's exactly what as it reads. It requires that the judge of the General Sessions Court there in Scott County to devote full time to the duties of that office, and prohibits the judge from the practice of law or any other employment which conflicts with the performance of the duties of the judge. So what they're doing is the county there, they're bringing, and of course the judge she does have her own law practice, but she has agreed to go with a salary full time there. And I think that it also includes their benefits, if any, that come with that. But anyway, that's it, sir.
Thank you.
With that,
Members,
I'll renew my motion.
Thank you. Members, you heard the explanation of the bill. Do we have any questions for the sponsor? Question's been called. We're voting to send House Bill 2152 to civil full. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Civil full. Congratulations.
Thank you, Chairman and members.
Thank you. Brings us to item number 7, House Bill 2434 by Representative Terry. We got a motion and a second. Representative Terry, you're recognized on House Bill 2434. I do show an amendment.
Yes, amendment number, drafting code 014793.
That's exactly what I show. We got a motion and a second on the amendment. We're voting to add, amendment 14793 to House Bill 2434. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Representative Terry, you're recognized on the bill as amended.
All right. Thank you, Chairman and Committee. And this bill provides that a private entity or governmental entity is not liable in a class action lawsuit resulting from an event resulting in unauthorized access to or disruption or misuse of an information system or non-public information stored in an information system unless the event was caused by willful, wanton, or gross negligence on the part of the private entity or governmental entity.
All right, very good. Members, you've heard the explanation of the bill. Do we have any questions to the sponsor? And Representative Bolzo, you're recognized.
Thank you, Mr. Chairman. Good afternoon, sponsor. I've got a concern about the class action portion of the statute because the subsection B reads that a private entity is not liable in any class action resulting from cybersecurity unless the cybersecurity event was caused by willful, wanton, or gross negligence on the part of the entity, which raises a number of questions because in our tort system, liability can be predicated upon negligence, upon gross negligence, upon recklessness, or upon intentional conduct. And this particular language just carves out gross negligence as a standard that is applicable in the event that the case is filed as a class action, meaning, among other things, that if the conduct was intentional, there still could not be a class action. And I'm wondering whether that was the intent of the bill or whether it simply is drafted this way.
And members, you're welcome to go back and forth without being recognized.
Okay, thank you. I believe it was drafted that way. My understanding, I actually tried to come by your office to kind of walk through some of this. But my understanding is that gross negligence, and of course, I'm not an attorney like yourself, being a substantial and unreasonable deviation from the standard of care. And so, if they're obviously having a substantial deviation from the standard of care then they would be able to be sued under this. But is that your understanding?
My understanding is that if this were enacted, that it would immunize private entities from liability for something defined as a cybersecurity event unless the conduct was willful, wanton, or gross negligence.
Correct.
And what that would mean is that the private entity is not liable in a class action if the conduct were negligent, reckless, or intentional. And so I think if the intent is to cover the field of potential types of liability, this language does not actually accomplish that. But even more critically, I think a class action actually provides a useful function in our civil tort system because it allows groups of claims to be aggregated together to be resolved efficiently in one forum. And I'm not aware why we would want to immunize any private entity against a class action that was based on negligence if the negligence actually caused harm to some party or parties. And so I think I understand the intent behind this, but as it's written, it's not something that I can support because I think it would do violence to the civil justice system to immunize private entities from acts of negligence. I mean, the system is there to provide a remedy for those who are injured by negligence, gross negligence, recklessness, or intentional conduct. And I'm not aware why we would want to provide this type of immunity to private entities for this particular type of conduct called cybersecurity event.
Thank you. And to that point, a couple of things and I'll maybe give you some background on why this was brought to me and some of the issues that are out there. And this would not impact the clinic that's in my district, but my clinic got hacked. One of the clinics, medical clinics, and we are mandated federally to keep medical records. And so the government, if it mandates that you keep these, and whether it's market mandates or governmental mandates, but then regardless of what you actually can do to meet the standard to protect that information, and you still get hacked by another nation state, which has occurred to not just this clinic, but also occurred to a subsidiary of United Healthcare just last week. And so if you're putting businesses in a catch-22. You have to do this, keep this information, but then you can't, even though you've got the standards there that you're trying to protect this information. As you know, when you update your computer all the time, you're having to put new software on there, protection software, and you may not be able to keep up. And then all of a sudden, you have some nation that now gets your information. They want to put it on the dark web. So how do we protect these entities who are doing their best and they're doing good faith effort to protect everybody's information, but you still can't do that. You can't keep up to that. If governments can't do it, how do we expect a business that's mandated to do it by the government? So that's what the impetus is behind this bill.
All right. Do you mind if we go out of session? We got somebody here that wants to testify on this. Mark Kalis? All right. Without objection, members, we're out of session. And how do you pronounce your last name?
It's Chalos.
Chalice. Okay. Sorry
Yes.
about that.
Thank you,
And
Mr.
Mr. Chalice, if you'll just make sure your red light's on, which it is, when you just identify yourself, who you're with, and you'll have 3 minutes. So.
Okay. Thank you, Mr. Chairman. My name is Mark Chalos, and I'm here on behalf of the Tennessee Trial Lawyers Association. And I echo some of the comments that Representative Bolso made. This bill would protect wrongdoers and significantly disadvantage Tennessee citizens. Companies that are doing their best and are trying to keep up with the latest security would be exercising reasonable care. So they would not, even under the current law, necessarily have liability. Data breaches in all their forms are dangerous. They expose our and our family's most private information, including personal health information that we want to keep private. Under current law, anyone who chooses to gather this private information or is compelled to by the government has an obligation to use reasonable care to protect it. That's it, reasonable care. This has been the standard that has applied in our civil justice system since the founding of our country, and even before in the English system. That's the standard that governs all of our behavior, from the person in the street to the biggest multinational corporations. This bill instead would provide immunity to anyone who has gathered this information, not just small clinics in Tennessee, but anyone who has impacted Tennessee citizens who fails to use reasonable care to protect that information. So who would this bill protect? We have to look at where these data breaches have occurred and what companies have been involved. And these are repeat offenders, a lot of them. Google, Facebook, TikTok, Cambridge Analytica, Amazon, Apple, to name a few. These companies, big tech, would be let off the hook for their failure to exercise reasonable care under this bill if passed. And the way it works in practical terms, and I'm a lawyer who practices occasionally in this area, the data breaches often affect consumers nationwide, including Tennesseans. The cases are brought often as class actions. They're brought all together. Citizens from all the different states are there. If this bill passes, Tennessee would be the only state that immunizes negligent actors from liability. Tennesseans would be put at a significant disadvantage. They'd be treated in an unfair way. And while other states are actually going the other direction, they're doing things to protect citizens' data, to protect from their private health information being exposed, protect their families' private health information, their families' private information being exposed. This bill, however, would send the message in the opposite direction to big tech, to state actors, that Tennesseans are less protected. So for those reasons, I would respectfully encourage this subcommittee to vote against this bill. Thank you.
Thank you. And we'll see if we get some questions for you. Members, we got any questions for the witness? All right. Seeing none, we appreciate you being here today and your testimony. Thank you.
Thank you, Mr. Chairman.
All right. Without objection, we're going back in session. And Representative Terry, you're recognized. We don't have anybody on the list, but would you like to wrap us up?
Yeah, it's actually been brought to my attention that there may be a drafting error in my bill. And if you guys would indulge me, I'd like to roll this 1 week to fix that and address any other questions or concerns that the committee may have.
Very good. And thank you for doing that. And members, without objection, we're going to roll House Bill 2434 1 week.
Thank you, Chairman and Committee.
Thank you. All right, members, that brings us to item number 16, House Bill 2310 by Representative Ritchie. We got a motion and we got a second. Representative Ritchie, you are recognized, and I do show an amendment. Would you like to run with that?
Yes, Chairman. It is Amendment Drafting Code 014190.
That's exactly what I showed. We got a motion. Do we have a second on the amendment? And a second on the amendment. Does it rewrite the bill or?
Yes.
Okay, we're going to vote to add Amendment 14190 to House Bill 2310. All those in favor signify by saying aye. Opposed, no. The ayes prevail. And Representative Ritchie, you are recognized on House Bill 2310 as amended.
Thank you, Chairman and Committee. House Bill 2310 will end up prohibiting the knowing removal of a minor from the state of Tennessee without the consent or knowledge from a parent for any procedure that is illegal here in the state of Tennessee. It creates a Class C felony for an individual that takes a minor out of the state without parental consent or knowledge. And down in Section E2 creates a civil action that may be brought to that individual that knowingly does that. And with that, Chairman, I stand by for any questions.
Thank you. And members, we do have somebody here to testify. If y'all would like to go out of session, we'll go out of session without objection to hear from Heather Thomas. Heather Thomas. And just make sure your red light's on. You'll have 3 minutes. If you'll just state your name and who you're with, and we'll start timing just as soon as you start talking.
My name is Heather Thomas. I'm a Williamson County resident and a lifelong Tennessean. I'm an entrepreneur, a wife, a mother, a Christian, and happen to have a transgender son. HB 2310 is not necessary. There are already other laws and multiple hoops to jump through that require parental consent. This body speaks a lot about parental rights, and parents often depend on a community of folks to raise their families, transport them to and from school, doctor's appointments, etc. This bill could strip them of those rights. For instance, who's included in this bill? Grandparents, step-parents, aunts, uncles, brothers and sisters? What about single-parent homes? Where one parent is absent? What about parents with disabilities who are homebound? What about transportation companies, airlines, trains, buses? Can doctors talk about options of care? I know in this amendment you didn't talk about that, but those are other parts of it. We're just regular families who work with, go to church with, have as neighbors, and whether you agree or not, you've already stripped us of our ability to care for our children, even though every major medical association supports such care. We stand and say the pledge, and the last 6 words are with liberty and justice for all. But this is not what this bill represents. Liberty is defined as the state of being free within society from oppressive restrictions imposed by authority on one's way of life, behavior, or political views. We are not only Tennesseans, we are Americans, and if our state won't provide the care our families need, we should have every right to seek help in whatever way we choose elsewhere. I can tell you that my child would not be alive today if it weren't for gender-affirming care. Parents and children are facing increasing hostility in Tennessee due to the misinformation and false narratives being spread about the trans community. Statistically, transgender people are some of the most vulnerable and least threatening members of our population. From this legislative body alone, I've heard and been called a child abuser, an indoctrinator, a pedophile, and for the record, people don't and can't persuade someone to turn or be gay or trans. There's an undeniable correlation to those who have mental health issues, not because they are transgender, but because they are othered, treated as lesser, bullied, and violently victimized. I want you to understand that there is a direct line from what this legislature is doing to the mental health of our struggles of the trans community. Every time a trans person is murdered, you are part of the trail of hate that led there. For every trans person that self-harms, you are complicit in that. Your words and laws not only defame people, but they also dehumanize them. Matthew 19:13 says, "Let all the little children come to me and do not hinder them, for the kingdom of God belongs to such as these." Jesus would be flipping the tables if he were here today. When is enough cruelty enough with liberty and justice for all?
Thank you, Ms. Thomas. Members, we have any questions for Ms. Thomas? All right. Thank you for being here. We appreciate your testimony today. Without objection, we'll go back in session. Representative Ritchie, you are recognized on House Bill 2310 as amended.
Thank you, Chairman and committee. And just to clarify, this particular bill does allow for parental choice. That it specifically states that inside of this bill. It says parent or guardian. So if another individual takes one of our kids outside of the state without the parent or guardian's permission, that's what this is specifically says in black and white that it addresses. It has nothing to do with any of the procedures or anything that's already in TCA code. This is just to prevent bad actors from coming in and taking our children to go somewhere else without that child's parent or guardian giving them permission to do that. So it's very simple from there, but I stand by for any additional questions. Ask for passage.
Thank you. Leader Lambert, you're recognized.
Thank you, and thank you for clarifying that. I mean, I appreciate the public comment, but it really didn't address this bill, and that may be something that just needed to be said for other bills out there or something else. But this bill is the same as any other medical procedure. I mean, as a parent, I can't fathom if someone else without me and my wife's permission or even knowledge took one of our children to another state or even within this state for any kind of medical procedure. I mean, that's just bizarre to me that anybody would even advocate for that. I mean, a parent should be intricately involved in their child's medical decisions and care. And again, we can have spirited debates as to what should be allowed or not allowed under the law. And we've done that on other bills. But my God, this one just makes sense. I mean, no one besides a parent should be taking a child anywhere for a serious medical procedure. And surely folks on all sides of this issue would agree. These are significant and serious medical procedures that can and many times do have severe side effects that should be done only in the laws in Tennessee, at least, once someone is an adult, but certainly should not be someone besides a parent making those decisions for the child in that family. So I thank you for carrying the bill. I mean, I appreciate the testimony, but it just, this bill, it seems like with the amendment, you've kind of shored that up and made sure that parents can make decisions with their children on what to do. But for other people, they just have no business taking a child anywhere else for any kind of medical procedure. Thank you for bringing the bill. I certainly support it.
Thank you. And Representative Ritchie, would you like to respond to that? Or?
No, I would just clarify, or just to echo what Leader Lambert was saying is, with this particular language, if a parent or guardian still wants to be able to have their child or a young adult in their custody, whatever, to go through one of these procedures, they still have full right and capability to go and find that care procedure, whatever it is. This is protecting parents that do not have knowledge of somebody coming in and taking their kid to another state to do a procedure that's not legal here in the state of Tennessee.
Thank you. And Leader Lambert for follow-up.
Thank you, Mr. Chairman. And again, not to wander too far to field, but I will say just publicly, we spent an enormous amount of time last year on this topic, and there is a growing body of medical research that supports the fact that surgical intervention in a child who is suffering from gender dysphoria is more damaging than helpful. There are countries in Europe that have reversed course on this. There are many states in the United States that have reversed course. I would just ask folks to have caution and exercise.
All right, listen, you can either stay and be quiet or you can leave and watch from the hallway. So it's up to you.
Representative Ritchie,
you're recognized.
I'm
sorry.
asking folks to, again, study the medical testimony that's out there. Look into this very carefully before you go through with something, or anyone would go through with something that is irreversible. And so thank you again for bringing this to the forefront. And you all can yell at me all you'd like, and I'll be in the hallway later and you can yell at your heart's content. But in a committee, please don't just speak out. That's all I would ask, is to have the respect that I would and have many times exercised towards you in the audience. I won't yell at you, and don't yell at us, please.
All right.
Well, we tried. So
all right.
Thank you, Mr. Chair.
No, you've already had your time. Representative Capley, you're recognized.
Good bill sponsor. I want to sign on. Appreciate you.
All right. Representative Grills, you're recognized.
Thank you, Mr. Chairman, and I want to echo what some of the comments that Leader Lambert, I agree with him 100%. We're at a crossroads in our nation, and we're fighting for the very fiber and the heart and soul of our nation. And I appreciate the fact that you're going to one day come down on the right side of history with bills like this and the efforts that you're moving forward with, because
all right.
I just appreciate the fact, Representative Ritchie, that you had the courage to bring a bill that's controversial like this, and I too can't wait to vote for it.
Thank you. And Representative Ritchie, just to clarify, a parent can give permission to an uncle or aunt to transport the child if they want to?
Yes, that is correct.
All right. We don't have any other, we don't have any other members on the list, so the question's been called. We're voting to send House Bill 2310 to civil full. All those in favor signify by saying aye.
Aye.
Opposed, no. The ayes prevail.
Thank you,
Civil
Chairman of
full.
Committee.
Next up is item number 18, House Bill 2888 by Representative Todd. We got a motion and a second. Representative Todd, you are recognized, and I don't show an amendment.
Thank you, Mr. Chairman. I appreciate that. The intent of this bill is to provide a process for a property owner to seek relief from a government entity when that entity's action results in the property's loss of value. It does not apply to any regulations against public nuisances, regulations that protect health and safety, regulations enacted before the date of acquisition or inheritance by the owner, or any land use regulations that comply with federal law. If the entity enacts a new land use regulation resulting in the restriction of existing uses or devaluation of property, then the government entity must provide mailed notice to the owner within 10 business days of the enactment. The notice must state that the new regulations may impact the owner's property rights. If the property is devalued by 10% or $50,000 due to the enactment, the owner must be provided just compensation by sending written notice to the government entity. Once the notice is received by the governmental entity, they have 90 days to respond. If the entity does not respond, does not provide just compensation, or refuses to modify or remove the regulation that would allow the owner to utilize property for its intended use, or it denies any compensation that's due, then the owner has a cause of action against that entity. If the owner is the prevailing party, the court may award reasonable attorney's fees and court costs. So this sets up a process outside of court first for a person whose property has been diminished, their value's been diminished, or their rights to that property have been reduced. And then if they're not satisfied, if the governmental entity does not provide them a just answer and reasonable compensation, if that's proven, then they can proceed with a court action, and it lays that out. So this is a framework to hopefully keep a lot of these things out of court, but protect people's property rights. With that, I'll be glad to take any questions.
Very good explanation. Members, we got any questions for the sponsor? Seeing none, you must have done an excellent job. We're voting to send House Bill 2888 to full civil. Representative Bolzo, do you have a question?
I did, Mr. Chairman.
You recognize.
And it's something that I've discussed with the sponsor about. I think our body of law in Tennessee with regard to taking an eminent domain is well developed, both procedurally and substantively. And as much as I respect the intent of this new statutory framework, in my view, the current framework that we've got, which has been developed over many years, is actually superior to the framework that would be introduced where this bill passed. And so respectfully, Mr. Sponsor, I just want to let you know that I'll be voting against this one.
All right, we'll try this again. We're voting to send House Bill 2888 to full civil. All those in favor signify by saying aye. Opposed, no. The ayes prevail. It's full civil. Congratulations. We got one more bill, so we're going to take a quick recess. Very quick, hopefully. All right, we're back in session. Members, without objection, item number 3, House Bill 2282 will be rolled 1 week. Seeing no further business, without objection, we stand adjourned.